As, as you're aware, we are in the middle of a lecture series together on climate change. And I said, I think at the beginning of that lecture series,
It's
that
better.
we would continue with that lecture
It's
series,
better.
at least in
Yeah,
case the news
turn it up a little.
got in the way. And this week, the news has gotten in the way. So I'm going to interrupt that lecture series to talk about what's in the news, and I think probably on everybody's minds, which is the leaked opinion from Justice Samuel Alito uh, that appears to indicate that there is now a majority on the Supreme Court for overturning the Roe v. Wade decision that created the constitutional right to abortion. And I want to discuss the legal, the social, the political implications of this, and to, I hope, put it in a somewhat broader context, a context that will be familiar from previous lectures, but I think nevertheless, uh, we should be rethinking the question, among other things, of the legitimacy of the Supreme Court. And so to frame this in a more general analytic approach, I want to start with a phrase that was suggested to me by my friend Shana Strom at the ACLU, which is that around 40 years ago, in the early 1970s, I guess we're really coming up on 50 years ago now, a conservative moonshot was launched, a radical effort at policy change or reform. But unlike other moonshots, this one did not proceed via direct federal legislative initiative, but instead proceeded in civil society. It's associated with the Federalist Society and the Powell Memorandum. And generally, the idea was that to change American society in a more conservative or a more libertarian direction, perhaps an essential battlefront was to remake the federal judiciary. In order to remake the federal judiciary, it was necessary to remake the intellectual climate at America's leading law schools, and perhaps to remake the legal climate of the United States as a whole. Uh, Going all the way back to Alexis de Tocqueville, there have been a lot of people who've observed that the United States tends to give an outsized role to lawyers, that almost all of our politicians and obviously, I guess, all of our judges are lawyers, that the legal profession has a particular culture to it. It's not just a matter of getting a law degree. There's a kind of process of socialization or acculturation that occurs. And hence, because of the dominance of lawyers in politics and the judiciary, the nature of legal culture in the legal profession has an outsized role in shaping the overall political and cultural climate of the United States. And I don't know if the Mercers and the Koch brothers and the others who ultimately funded the Federalist Society, which is the single most important organization in bringing about this revolution, had in mind Tocqueville and the outsized influence of legal culture in shaping American culture and politics. But they certainly either got it right or got lucky, in the sense that they poured millions of dollars into hiring more conservative law school professors at Americans' leading law schools, into um, promoting students with scholarships and professional support who were willing to take seriously conservative ideas, attend summer institutes, go to various seminars and speakers at law schools, and that eventually this created a critical mass of highly networked, very conservative lawyers. And slowly but surely, as conservative presidents, beginning with Ronald Reagan, began to be able to appoint these newly trained lawyers to the federal bench, they began converting the nature of jurisprudence, the guiding ideas that determine how the Constitution is interpreted by judges, and most importantly, by the highest court, the Supreme Court in the United States. And if you want the background, I recommend the book by Stephen Tellis, The Rise of the Conservative Legal Movement, which I think is a very, sorry for the pun, judicious, balanced account of the rise of this movement and what is, I think, the result of the success of this radical policy initiative, this moonshot, this effort to fundamentally remake one of the three main institutions of the federal government, and frankly, in the 21st century, the most functional branch of the federal government, is reflected in this court in the 6-3 majority that conservatives have. And even within that majority, in the apparent majority of what I would call conservative or ideological purists, as opposed to institutionalists or pragmatists within the six conservatives on the court. That reflects the success of this movement, the movement to remake the courts, funded by conservatives, explicitly planned and contained not exclusively, but in an exemplary way in the activism of the Federalist Society. And the result is the opinion leaked this week by Justice Samuel Alito overturning Roe v. Wade. And now the idea that fences are being erected in front of the Supreme Court to protect the Supreme Court and its members from possible protests or worse. And I obviously don't like the symbolism, but I think it captures very nicely the degree to which this movement and the money behind it puts the court in a very different space, legally or politically, than it has been for much of the last 100 years, and also at loggerheads with the majority of Americans. And so I want us to focus not only on the idea, and you may remember I gave a lecture on this very topic in the aftermath of Texas passing SB 8 and the Supreme Court hearing and us getting access to their questions in the Dobbs v. Jackson Women's Health Organization case, in which Alito's opinion has now circulated. That we may very well be on the cusp of living in a Roe v. Wade world. We should have anticipated, I think many of us did, that this would be the likely path that the Supreme Court would take. I think the thing that is surprising is that it's going there so quickly, that it may happen this year. And I want to be as clear as possible about this from the outset. This is a leaked draft opinion. And that is very different from a final opinion. And those of us who study the court know that these opinions go through multiple iterations and negotiations. If I have it right, Chief Justice John Roberts assigned this opinion to Justice Samuel Alito, in part anticipating that Alito would write an extremist opinion, that he would not have due respect, what people like me consider due respect for stare decisis, for the principle that decisions that have already been made generally should be respected by the court, because one of the roles of the court is stabilizing the legal framework, the rule of law that all of us rely on, that if you change settled case and law too quickly, people who have relied on the rights and procedures and entitlements that that law creates will feel that they can no longer rely on the institution of the Constitution and the law to stabilize their expectations, right? And so, with the knowledge that Alito does not subscribe to that view, that he is what I'm calling a conservative or ideological purist, which means he's of the opinion that if it's a bad decision, we should overturn it now. Our primary responsibility is fidelity to the Constitution, not fidelity to precedent. If precedent was wrong, precedent should be overturned, right? And do it today, because who knows what's going to happen tomorrow, but also because you cannot let bad law stand, right? And so the reason Roberts perhaps assigned this to Alito, we may never know, but this is my speculation, is in the hopes that Alito would write the kind of opinion that might not be able to attract a majority even of the conservative justices, and that would allow Roberts to peel away one of the four other votes that Alito needed, and to come down in a place where, as opposed to overturning Roe v. Wade would be incrementally reduced in its scope and the protection that it affords. And so, to be clear, right, I believe that the fact that this opinion has been leaked is probably part of a strategy to prevent Roberts from peeling anybody away. But what this means is that the opinion that we have in front of us, which was drafted, I believe, on February 10th, and at that time appears to have had 5 members of the court willing to work on creating their majority behind this opinion, would not be the final opinion, that there would be negotiation, there would be revision, there would be give and take, and eventually the decision would perhaps have been the same, but the content of the opinion would have been different. And so the holding, the law, the finding would have been somewhat different as well. We do not yet know whether the Supreme Court will definitely overturn Roe v. Wade. We certainly don't know if the opinion from Samuel Alito will have undergone important changes, even if the Supreme Court does overturn Roe v. Wade in a month or two. But none of that changes, on the one hand, that it seems likely that Roe v. Wade will either be overturned this year or soon thereafter, and that Alito's opinion does seem to reveal the direction that the court is headed in, not only on abortion, but more generally on revising or rejecting, overturning many of the important Supreme Court decisions of the last 100 years, and that the result is that we are going to live in a very different country if this court continues on this path. And so I think this raises then 3 questions that I'd like to focus on today. A narrow question concerning abortion in 21st century America. How will this decision affect that? The second, referring to constitutional law and how it's likely to change for the time that the conservative majority in the Supreme Court is able to guide the reinterpretation of constitutional law. I'm putting Roberts' court in scare quotes here, because it seems to me that in a sense, Chief Justice John Roberts has lost control of the court that he heads. He did not want to, right, sign Alito's opinion. He probably won't. And that is because Roberts is what is sometimes referred to as a conservative institutionalist. He believes, and we'll get further into this as we go along, that the Supreme Court depends for its power on its perceived legitimacy. And its perceived legitimacy depends on the idea that doing constitutional law is different from doing ordinary politics. And one key difference is that in constitutional law, the principle of stare decisis, the principle of respecting received precedent, is restraining on what will be done, and that Roberts' incremental institutionalist approach had been the fulcrum of the Supreme Court, that the it was necessary to get Roberts to go along with the other conservative justices, and he demanded, in exchange for his support, a more incremental, gradual approach. He seems now to have lost that battle with the new appointments to the Supreme Court under Donald Trump, three of them, including one of the most radical shifts in recent Supreme Court history with the death of Justice Ruth Bader Ginsburg. We now have a much more conservative court and a much more radically conservative, purist conservative court, where five justices appear willing to act without Robert's support in a less incremental, more radical way. And so then the final question is, well, what will this mean for the politics of the United States in 2022, in 2024, and in a country that is highly polarized around these culture war issues like abortion, but in general between its two parties? So let me start with that first question. What will this mean for abortion in the United States? There is some current controversy and even counting the number of states that are likely, as soon as Roe v. Wade is overturned, to no longer allow abortion. It's between 26 and 28 states. I think the accurate number is probably 28, but it depends on which states have laws on the books that have been dormant in the Roe v. Wade world, so dormant for the last 50 years, that might be revived, right, in the post-Roe v. Wade world. And so there are 5 of these states, including some relatively liberal states like Wisconsin, some quite purple states like Michigan and Arizona, where the old law may be revived, even if it's not at the state level, by local prosecutors. And so there may be uneven elimination of abortion rights within these states. There are 14 other states that could ban abortion very quickly, given their previous legislative history, and 13 states that have already on the books laws that will trigger as soon as Roe is overturned to make abortion illegal. And so you can see the map of the United States with the majority of the territory, and it turns out the majority of the female population that is of a childbearing age being states where abortion will be illegal soon when Roe is overturned. To break this down a little bit, you can see that of the women of childbearing age, it's about 50-50 likely to be in a state with a ban or in a state without a ban, with another roughly 3 million women where it's not exactly clear. Cases like Michigan, where it's not clear where the law will be enforced. That where women will lose abortion, white women are in a majority of the women of childbearing age. Where women will retain the right to abortion, the demographics look more like the future demographics of the United States, kind of a 50-50 split between white women and women of color. That the largest states here, right, Texas, Florida, Ohio, Georgia, North Carolina, Michigan, Arizona, have millions of women who will lose the right to abortion under this new law. Now, measuring what the impact will be is, I think, more complicated. And so, to be as clear as possible, I know many of us remember a world in which there was no right to abortion, the pre-Roe v. Wade world. And I want to be as clear as possible. We will not go back to that world. And in saying that, I mean two things. The first is that was a world in which there had been no constitutional right to procreative freedom, including abortion. And it's one thing to move in that world, it's another thing to return to that world. And so when we return to that world, with a world where there's no longer a constitutional right, many women will still consider it to be their right and will therefore continue to seek access to abortion. Many other people will try to assist providing those women abortion. And so what this map shows is looking at the intersection of geography and wealth, right? How far do women live from states that will have legal abortion, in particular from clinics in those states that will provide abortion? And what is the concentration of poverty in the areas that are far from abortion clinics in other states? And the reason to pay attention to the intersection of geography and poverty is because it is likely to be the case that many women will travel from states where abortion is illegal to states where abortion is legal. But the ability to do so will depend on having the means to travel between states, the ability to take some time off of work to do this and not be fired, right? Perhaps family support. And that will depend on the relative affluence of the families. And so, to be as clear as possible, the dark orange areas are areas, I guess that's really kind of a rust color, where the estimate is that the availability of abortion, the number of abortions might decline by as much as 20%, right? And to be clear, that's not 100%. And this reflects then what we've seen in Texas after SB 8 was passed, right? The law that makes those who provide or assist in providing abortion civilly liable for a $10,000 fine or judgment. And what we saw in Texas, right, is that the number of legal abortions went way down after this law was passed, down by about 50%. Please note, right, that the abortion law was not designed to challenge, it was designed to evade Roe v. Wade. And therefore, it, on the one hand, didn't create a state agency to enforce it. And on the other hand, allowed abortion up to around 7 weeks. And so there are still legal abortions occurring in Texas. But please note, what's really striking about Texas is after a little while, the overall number of abortions occurring uh, for women who reside in Texas has returned to the pre-SB 8 level, in part because a substantial number of women have gone out of the state to get abortions, but also because a substantial number of women have gained access to abortifacient medication, abortion pills, right? And those pills induce abortion quite safely in the first trimester. And the fact of the matter is that they can be sent inconspicuously through the mail, not only from within the United States, but from outside of the United States. And so the ability of people in Texas to prevent those pills from reaching women who want them has been highly limited. And the result is, again, different from the 1960s, from the pre-Roe world. There's a new way of gaining access to abortion, at least for women who are able to tap those networks, those resources, those connections. And so while the world in which abortion is no longer a constitutional right will be a world in which it will be more difficult for women to get abortions, in which therefore some poor women will end up having children that they would not have had in today's world, or a world where abortion was more readily available. That doesn't mean that every woman living in one of these states will immediately lose access to abortion. I will just say very quickly, one of the things that the research on abortion seems to show is that women who avail themselves of abortions early in life, when it, as far as they're concerned, doesn't make sense for them to have a child, often do better in life. They're able to complete their education, they're able to start their careers. They don't have to marry a man that they were having a casual relationship with and that they're not particularly interested in starting a life with. They don't have to become a single parent. They end up with a career and education, a stable, good relationship, hopefully a marriage, having children later in life, and they and their children do better as a result. That seems to be the dominant scenario around abortion in the United States over the last couple decades. Now, we can look a little bit more at the demographics of uh, who gets abortions and then who is more likely to be affected by this. And as you can see, it varies with state. There are states in which African American women are the main category of people who get abortions, and that seems to be nationally the main category. There are states in which it is Hispanic women who are the largest group, and there are states in which it is white women who are the largest group. The concentration of women in poverty living in states where abortion access will probably be lost is around 20%. These tend to be poorer states. Depending on the state, they can be more or less diverse states. And the overall implication of this seems to be, right, with the red dots on the map looking like where abortion clinics are going to close, that poor women and women of color are going to have much more difficult times gaining access to abortion in a post-Roe v. Wade world, and that raises issues of social justice for not only them, but also for their children, given what we know about women who have children because of lack of access to abortion. They tend to stay poor, their children tend to be poor as well. And again, when we look at this map, one of the things we can see is that there's a strong concentration of states that are going to or have already eliminated access to abortion in the so-called Bible Belt, in the southern states that tend to be least generous when it comes to providing social welfare for children. And so the likelihood is that one effect of this will be a increase in childhood poverty and overall poverty, especially for women of color in the United States. Now, transitioning from the general issue of what access to abortion is going to be like in a post-Roe v. Wade world and more into the politics, I want to note that another way in which the post-Roe v. Wade world is going to differ from the world prior to Roe v. Wade is that there will be a large number of people in this society, including those in relatively affluent, relatively liberal, relatively democratic blue states, that will react to the Supreme Court decision by putting more abortion protection in place as opposed to rolling things back. And some of those states, California among them, are considering provisions that make it absolutely clear that women are welcome to come from other states to get abortions. And maybe even some of those states, and certainly organizations like Planned Parenthood, will try to facilitate women from neighboring states traveling to the states where abortion remains available in order to get their abortions. And I think one of the things we can expect to see around this, right? Abortion related travel, as well as um, around the mailing or making available of abortifacient pills, is increasing tension between the states trying to restrict access to abortion and the states trying to grant access to abortion. And here I'm going to move out of a legal and political framework and into a moral and religious framework for just a moment to say that I think, and I think I know you pretty well. You probably are, most of you, not in favor of overturning Roe v. Wade, but I think we have to take seriously the idea that as a matter of theology, as a matter of conscience, as a matter of philosophy, there are a substantial number of people in the United States who reasonably view abortion as the killing of an innocent human being. Now, I'm not talking about the legal implications of that view. I don't think that in the United States, with the separation of church and state, we can impose that view on others without having a sectarian and probably authoritarian state. And so that's one of the issues that this raises, this new Supreme Court decision, is in a sense it puts states very much in this very difficult position of having to resolve this issue politically. But when we just look at the fact that there will be a number of states that will increase their protection for abortion and maybe try to afford opportunities for women to travel to their state to get abortions, when we think about the fact that it may be that people who are offended by this in states like Texas or Louisiana, Mississippi, Florida, Georgia will leave those states for these states where they're expanding abortion rights, we can expect to see increased polarization, increased fractiousness in our politics. This is not going to be good for civility, for our capacity to get along with each other or compromise, work together across partisan lines. Very quickly to look at public opinion here. This is pretty stable, which is to say the data here is collected from, I think, a very good poll that was conducted after SB 8 was passed in September in Texas. But having said that, these numbers tend to be pretty consistent within a few points across polls. So how many people want Roe v. Wade to be revisited? It's a little bit less than a third of Americans. How many people want it to be left as is? It's approaching 2/3 of American. How many people want abortion always to be legal? It's around a third. How many people want it to be legal with limitations? Almost another third. So around 2/3 of the population support some form of legal abortion. And then how many want it to be illegal with exceptions? 24%, a quarter. How many want it to be always illegal? Right about 10%. And so as a society, generally speaking, we are supportive of Roe v. Wade. We are supportive of abortion rights, although we are clearly divided on this issue. And this then raises a more general question about jurisprudence. And so my second big question now, is about jurisprudence, and this question overlaps with the question to do with politics as well, in ways that I hope will become clear. But let me start with the jurisprudence question. And I've put on the board my old teacher, Ronald Dworkin, one of the most important legal philosophers of the last 50 years, one of the people who did more than anyone to articulate, I think, a philosophically respectable foundation for the Roe v. Wade decision, but more generally for the idea that the Constitution as a living document should be interpreted according to the morality of the period in which we find ourselves now. And so, broadly speaking, the idea of a living constitution and how that could be reconciled with the idea that we are still governed by a constitution that was written nearly 250 years ago. And to look then at the Roe v. Wade decision here in a little bit more detail for just a moment, it's worthwhile noting that it goes back, its lineage, the cases that it builds on, goes back into the middle of the 1960s. There's a very important decision, Griswold v. Connecticut, in which the court granted married couples the right to birth control, and in so doing, it referred to the constitutional right to privacy. And it is worthwhile noting immediately that neither privacy nor abortion are enumerated rights within the Constitution. They're not mentioned anywhere in the Constitution or the Bill of Rights, as, by the way, neither are women, right? And so if there is a general right to privacy in the Constitution, it is implied without being enumerated. And Dworkin and the justices in the mid 1960s and a whole body of law and philosophy and legal thought in the middle of the 20th century until the present has been committed to the idea that we need to think through not only what the Constitution explicitly contains, but what the guiding principles and logic is behind the explicit rights created by the Constitution. Why are we protected from housing soldiers without giving them permission? Why do we have protections against search and seizure without probable cause or a warrant? And the holding of the court in Griswold and other cases is because this was understood to be in the 18th century what protecting privacy required. But as we moved into the 19th and the 20th century, into a world in which our phones could be tapped or we could surveil our emails, etc., we needed a more expansive understanding of privacy than the literal language of the Constitution itself provided. And that similarly, the Constitution did not protect a right to birth control because in the 18th century, that was not an issue. But not allowing people to invade your home is very closely related to protecting the autonomy of what you do in that home. And as the technology and culture evolve, and as we turn to thinking about what autonomy means in the middle of the 20th century or the first decades of the 21st century, it seems increasingly to include procreative freedom. Now that we have birth control, now that we have the ability to use ultrasound technology or to do DNA testing, we can see much more about what our possibilities are, what the consequences of carrying this pregnancy to term will be for the health of the mother, for the health of the fetus, for the likely well-being of both of them together. And so this is the set of ideas that eventually were expressed in Roe v. Wade as including a right to abortion in the first trimester unproblematically, maybe also in the second trimester as part of the right of privacy, procreative freedom, and autonomy. And the language that is used here is the penumbra of the Constitution, which is a metaphor, right? The less dark part of a shadow during an eclipse, that's the penumbra, right? It's the margin as opposed to the center, but it is implied, even if it's not explicit. This is the way we should read the Constitution. And there's a related idea that I think is extremely important, especially the 14th Amendment to the Constitution, the critical post-Civil War amendment, which guarantees equal protection under the law to all persons born in the United States, right? And one of the arguments that Dworkin makes about abortion is that only persons already born are assigned legal personality, become legal persons, and therefore have rights and legally protected interests under American constitutional law. We might, as a matter of conscience, to do with our religion, our theology, our morality, believe that there are rights and interests that are the possession of people who have not yet been born, fetuses. But having said that, on the one hand, that tends to rely on a religious argument about when the ensoulment of the fetus occurs, that we cannot make as a constitutional legal argument in the United States, given the separation of church and state. And it involves assigning legally protected interest to entities that do not yet count as legal persons as far as the Constitution is concerned. So a positive argument and a negative argument. And while I believe these are good arguments, I think it's worthwhile noting that these arguments very quickly produced pushback from conservatives in many quarters, and very quickly led to the call to overturn Roe v. Wade. It's a little hard to remember, but in the middle of the 1970s, abortion was not a partisan issue, right? There were the more or less equal numbers of pro-life and pro-choice Democrats and Republicans. Neither party had a stance on this. The majority of the change in opinion on abortion appears to be driven by partisan identification. Republicans came to recognize that their party was pro-life and became pro-life. Democrats came to recognize that their party was pro-choice and became pro-choice. I wish we could get back to that world in which there was more partisan flexibility about this issue, less complete and inflexible commitment to the moral rectitude of one side or the other. But it appears that that is the world of the past. Now, let me spend a moment on the deeper jurisprudential issues here. And the view that Dworkin defends is often referred to as a view of the living Constitution. One way to put this is that there's just no reason why people in the 21st century should be governed by the limited understanding of the Constitution that reigned in the 18th century. The alternative view, the view that's sometimes called originalism, says that the only way to understand what the Constitution means is to understand what it meant to the people who framed it and the people who adopted it in the 1780s, right? And the response from the advocates of the living Constitution is that is intergenerational tyranny, that these were exclusively propertied white men. Roughly half of them were slave owners. They did not, in Abigail Adams' famous language, think much about the women. They didn't think about all kinds of issues that have come to the fore since then. They were basically exclusively Christian and rather narrow in their approach. They nevertheless gave us a constitution that contains explicitly and implicitly very general principles. And one reason someone like Dworkin argues that they did this was because they did not want to completely handicap and handcuff our ability to modernize the Constitution, to make it speak to the problems and issues and culture and understanding of later generations. And they therefore gave us a mechanism for reinterpreting the Constitution to make it work for later generations. That mechanism is judicial review, as it's contained in the Supreme Court, and more generally, the common law approach to judges balancing the explicit content of the law and the guiding normative understanding of the culture that helps us to understand how that law should be interpreted and implemented. The parallel distinction here between enumerated and implied rights suggests that on the one hand, there are the rights that are explicitly stated, and on the other hand, there are rights that can be found within the principles and logic guiding the Constitution. The originalists want to say we should only have enumerated rights because there's no right to abortion explicitly stated in the Constitution. We cannot claim that there's a constitutional right to abortion. The living Constitution theorists want to say, no, we can find a concept like privacy and autonomy is being protected in the Constitution, and the implication of that is that abortion should be protected. I will note finally that there's a further issue here, and I'm about to go into some of the details, but this is the issue of what's sometimes called the Delegation Doctrine. And so one of the big issues in American constitutional history occurred in the mid-1930s when Franklin Delano Roosevelt proposed that the Supreme Court be expanded because the Supreme Court had been consistently invalidating the legislation that was critical to the New Deal. There's the famous switch in time that saves nine, and the idea that one justice retiring, another couple changing their views, allowed the end to the so-called Lochner era, in which property rights were thought to be paramount and restricted all of this other kind of federal legislation. If we go back to an originalist reading of the Constitution, does this not only undo the rights revolution of the last 70 years, but also potentially undo the entire delegation doctrine and much of the development of the administrative state over the last 100 years? And to illustrate that, I will just mention again something I've mentioned to you before, that there's another potentially very important case on the docket of the Supreme Court this session. It's already been argued. We don't know what the decision is going to be, but this is West Virginia versus the EPA, in which West Virginia is challenging not any specific set of regulations on coal-fired power plants, but the very power of the EPA to impose any regulations at all. And the reason that the EPA is, on West Virginia's theory, not permitted to regulate the amount of and kind of particulate matter that its coal-fired power plants emit is because Congress did not specifically set these standards, but asked the EPA to do it instead, delegated its regulative authority to an administrative agency. And so here the question is, will the Supreme Court, because it appears that an originalist, purist majority is now really beginning to transform American constitutional law, also attack the delegation doctrine? And this then raises, I think, a number of really important issues. And the issues can be stated as questions. Is it time to consider reforming the court in the name of democracy and legitimacy? And I'm not positive that the original funders and architects of the Federalist Society's strategy had this in mind in the early 1970s. But what is the case now, I think, is quite clear, which is, on the one hand, the federal judiciary is the most functional branch of the federal government, right? It does not depend on the outcome of the most recent election, at least not directly. It does not require making its way past a filibuster or getting to a veto-proof majority in closely divided legislative bodies. That really 5 people on the Supreme Court can bring about radical changes in the United States, and that those 5 people can be appointed by presidents who didn't win the popular vote, only the electoral college vote, as many of them have been, right? 3 most recently by Donald Trump himself, and confirmed by a Supreme Court where 50% of the members of the Supreme Court represent about 25% of the population of the United States. And so does democracy and legitimacy require finding ways of making the Supreme Court less potent as an institution for amplifying minority power in the United States in ways that strongly thwarts majority will and that allows conservative politics to progress on an alternative channel? A similar question: will political pressure build for court reform as a result of Roe v. Wade being overturned and other radical measures coming out of it? And then are there viable paths open within the Constitution for reforming the court? So turning now to the crux of the problem, right? It's that the court really depends for its function on being seen as legitimate, and right, it doesn't have any funding mechanism. It doesn't have any enforcement mechanism. It relies on the other branches to fund and enforce its decisions. And that in turn, right, that its legitimacy and its derivative power seems to depend on it being seen as a forum of constitutional principle, not as a partisan organization. That in turn seems, at least as far as someone like John Roberts is concerned, it being seen to be a gradualist institution, an institution that respects the principle of stare decisis, unlike ordinary politics. And we are presented here with the scenario in which several of the justices explicitly said during their confirmation hearings that they considered Roe v. Wade to be the settled law of the land, and now it appears they're voting to overturn it. It appears, in other words, that they may have lied under oath in order to get appointed. In other words, it appears that they look more like ordinary politicians who have donned black robes than like people who are doing something very different, working in a forum of constitutional principle, one that admits of controversy around constitutional interpretation, but in which there's something different going on. And if we have a Supreme Court that appears increasingly partisan, that appears no longer to be that different kind of institution, where the majority is fairly consistently doing things that the majority of Americans strongly disagree with, then we end up in a society where the Supreme Court appears increasingly illegitimate and may lose some of its power to protect the rule of law, something that we should be concerned about, not only because we don't like the current decisions, but also because of the value of the institution of the rule of law in providing freedom, security, and autonomy for all of us. So let me conclude by asking this question. How far back does the current court want to turn back the constitutional calendar, right? And I can give you three answers to this. One is they want to turn it back to 1950. That is to say, to erase the rights revolution. And that includes decisions to do with voting rights and civil rights, as well as rights that promote and protect autonomy and thereby protect procreative freedom, gay marriage, etc. A second answer would be turning the clock back to the 1930s to erase the Delegation Doctrine, and with it, potentially imperil the entire post-New Deal administrative state, not just whether the EPA can regulate coal-fired power plants in West Virginia, but whether the Food and Drug Administration can regulate our medicine or our food, whether consumer safety regulations can be imposed on our cars and our mattresses and our clothes, whether we could keep going, right? But all of these regulations that we take for granted potentially could be invalidated by Supreme Court decisions. And then I would just note very quickly that there appear to be at least a few culturally conservative members of the Supreme Court as well, who appear not to be terribly comfortable with the kind of post-traditional society we live in, with women's equality, with gender identity increasingly regarded by large numbers of young people as something that is elective, as opposed to something that is biological or socially assigned. And so all of this raises the question, right? Can this court really roll back generations worth of innovation and progress? And if so, if it tries to do that, what will happen to the standing and the legitimacy of the court? And there are good ideas for reform, ideas that I mentioned to you in a previous lecture from the Presidential Commission on Supreme Court Reform, like term limits for justices, like expanding the court, like making our court more like the German court, in which, as opposed to being a lifelong member of the Supreme Court, you're appointed to the federal bench, and then you rotate through the Supreme Court, maybe for a 5-year term, as part of what's sometimes called rotation and panel reform. I'll stop there. I'm sure you guys must have many questions and thoughts about this. Who wants to start us out today?
I will.
Flossie, go ahead.
Good. Okay, let us say that Roe versus Wade is overturned. That leaves us with the proposition that the life of the mother is not important as much as the life of the child, the unborn child is. And if we accept that proposition and we want to do something about it, we can decree with the law, of course, on our side, that all the abortion clinics remain open, not to administer abortions, but to help the mother to bring the baby to life. Therefore, she can apply to the clinic for a monthly allowance so she can go back to school or take care of her family. She can get a monthly allowance for food. And when she comes to term, right at the clinic, they will deliver the baby and keep her in the hospital for several days. And they will undertake to look after the child. That's one recommendation. Do not destroy the clinics. Make them a haven for the women who do not or cannot or will not bring the child to term. The other thing is, if that doesn't happen, what does happen? There will be so many babies left in washrooms, left in any public toilet, and possibly there will be a movement for any mother who is denied an abortion to carry her baby when she finally comes to term and present it to the Supreme Court by laying it on the steps of the building. There are all kinds of ridiculous answers to this terribly unjust, not only the law, but the injustice, the kind of thinking that permeates these men's brains.
And women's. Let's
Yeah, there are.
I put that image up there. Let's acknowledge that there are women, that the Supreme Court today is the most diverse Supreme Court we have ever had.
Yes.
Facially, right? If we look at what the people on it look like. Flossie, I hear your frustration and dismay in this. I think we have to be realistic about how we react to a world in which Roe v. Wade is overturned. Asking clinics to be converted to maternity wards is probably not the right approach. Certainly,
It's the approach that makes them look ridiculous.
But right, that it makes them look ridiculous to us. We have to recognize, right, that they are not looking at themselves in the way that we look at them, right? And so it seems to me a stronger argument is to look at what happens. And I've referred to this a little bit already, right, to women who are denied access to abortion and how it tends to trap them in poverty, to prevent them from forming families, to prevent them from having careers, and to make the argument, it's a hard argument to make in the current climate, but that if we're going to deny women the right to abortion, one of the things we should be doing is providing children with greater protection in terms of their income, their wealth, their education, right? We just lost the child tax credit, which moved, I believe it's 23 million children out of poverty, right? Part of the American Rescue Plan that expired in 2022. It would seem to me that a really strong argument could be made if we're going to have more children born to poor women as a result of this legislation. We need to do more to protect those children from what poverty tends to do to them. That I would be more inclined to pursue that argument. And in a sense, it involves saying to someone on the other side of the issue, are you really concerned about the children?
Yes.
If you are, let's then at least come together on something we agree about and do something to protect and shelter those children as best we can.
I can take it to the next ridiculous argument. Every child who survives abortion wears a little medallion that says, "Here I am, now take care of me."
John, I think you had your hand up.
Yes.
Yeah, I wanted to dissent from your view that this decision is going to increase polarization. I think it's going to reduce polarization. And I suggest anyone that's interested read Peggy Noonan's column this morning. I know I quoted her last week too on something else, but she starts out by noting that Ruth Bader Ginsburg, some time ago, who, after questioning the reasoning of Roe, said that in any case, it appeared to have provoked and not resolved conflict. The Roe decision was probably close to the worst thing that ever happened, strictly in political terms. This has nothing to do with whether you think abortion is good or bad, but as a political scientist, it clearly is the issue that propelled the right wing into the positions it's in and that led to so much polarization. But removing it should actually help, because now there are no more national decisions to be made, right? There's no issue pending, maybe about children, this and that, but that's not going to be a big emotional issue. Instead, the focus is going to be on the states, and the states are pretty much divided into red states and blue states, where there's a great consensus within each state about whether abortion should be abolished or whether abortion should be permitted. And so that takes that political battle pretty much out of contention. In fact, Peggy Noonan says that removing this issue will improve both the Republican and the Democratic parties. The Republicans can can go beyond just getting excited about this emotional, moralistic issue, and the Democrats, because they can appeal to middle direction voters and even appeal to people who are pro-choice, instead of ruling them out of the Democratic Party, which has pretty much been the case for the last 10 years or so. So I think it's an argument well worth considering.
Hello.
Yeah, and I have considered it, John. And if this
Who is this?
were depolarizing, I think that would be something to be said for it. But having said that, I'm not inclined to think that this is going to be depolarizing, in part because, as I've suggested in this lecture, one way to put, my punchline is that this is the tip of the iceberg. This is not an isolated decision, right? And the second thing to note is that I think this will probably embolden the Republican Party in terms of pursuing culture war issues. And probably, I suspect this will be the case. I think we're already seeing this in Wisconsin and Michigan, the states that have the old laws on the book, that the Democrats are really going to campaign on the idea, if you don't want to lose your abortion rights or other rights to be further scaled back, you got to vote for us, right? So we're seeing this so-called Don't Say Gay or parental rights legislation in Florida now spreading to many other conservative states. We're seeing anti-transgender laws to do with regulating schools and what can and can be taught spreading to many other conservative states. That the reason that abortion became such a mobilizing issue on the right is not simply because, as a matter of principle, they felt that the fetus is a person, and as such, this was a awful miscarriage of justice, injustice, to deny rights to, or to not balance better the interests of the fetus with the interests of the mother. It is because they are very uncomfortable, to say the least, that with the direction our society has moved in terms of sexuality, in terms of gender, in terms of race, in terms of religion, over the last 50 plus years. And so please note, right, that there will continue to be gay and transgender children and people in the red states. And if the approach of the Supreme Court is increasingly to say to those states, do what you will, none of this is a matter of constitutional law, I doubt seriously that many of the people in the blue states are going to say, okay, you're in a red state, it doesn't matter if you're gay and not allowed to marry. It doesn't matter if you're gay and not allowed to make medical decisions for your partner. It doesn't matter if you want to, in some way or another, bend or change your gender. You're in a red state, so we don't care about you, right? It seems to me we're going to continue fighting about these issues as long as we are divided between a party that basically is a party of maximal personal autonomy and a party that is a party of traditional religious and cultural values. And that nothing about this particular decision is going to change the nature of partisan composition in the 21st century. I have not read Peggy Noonan's article. I think you know I don't subscribe to the Journal, and so I don't get access to it. It's all behind a firewall for me. I'll try to find it, and maybe she'll change my mind. But based on what you're saying, I'm not yet convinced. John, go ahead.
We just disagree, and we can come back in a couple of years. You'll probably still be lecturing here and see. But I think that the abortion issue in the minds of Americans is unique. It's far more potent issue. They may well agree on gays and other sorts of issues like that, but it's nowhere near the emotional issue. And the same is true. Well, for Democrats, it's harder for Democrats to change anything. But anyway, we can come back. We can come back to it in the future.
And I'll just point out to you that you're in good company. I was in a discussion a couple of weeks ago with Sasha Isenberg. I'm not sure if you're familiar with him or not, but he has written a book recently called The Engagement, which is a long legal and cultural and political history of the change around gay marriage, right? And I basically tried to make the case that we shouldn't consider this to be a settled issue, that in 1973, we might have thought abortion was a settled issue, but 50 years later, we're on the cusp of seeing it unsettled. And why should we think that the gay marriage decision won't ultimately be overturned? And Isenberg basically said what you're saying now, that abortion is a uniquely contentious issue and that it doesn't seem like gay marriage is going to go the same direction. I hope you and Sasha are right, but I'm not yet convinced, I have to say, obviously.
I'll send you the column, and I can send it to anybody else who's listening that wants to read it.
Thank you, John. Anybody else with a comment or a thought for today? All right, please take care of yourselves. Be well, thank you, and I'll see everybody next week. Bye-bye.
Thank you, David.
Thank you, guys. Take care. Bye-bye.